So there are going to be people caught in a middle there. You can eventually sue, and maybe there's an argument that because they didn't comply with the DMCA takedown notice that they're not in the safe harbor. There's one possible remedy. These are the unknown things, though, that we're going to have to work out next. All right, so what are we looking at? We have something called the Fourth Estate Public Benefit Corporation versus wall-street.com LLC. And this is the summary. We're actually not going to read the summary because we want to read the whole opinion. This is a unanimous opinion, and the opinion is delivered by Justice Ginsburg, the notorious Ruth Bader Ginsburg, notorious RBG. Tactical, I believe I had asked if you could find something of a summary for that so that we know what the history is. How did we get here? What is Fourth Estate suing wallstreet.com over?
So it's actually a pretty simple history for something that's gotten all the way to the Supreme Court. Fourth Estate Public Benefit Corporation sued wall-street.com saying that the website had reposted their articles without permission. The trial court dismissed it, saying that they hadn't received their Copyright Office registration. So Fourth Estate appealed. The appeals court said, you haven't received your registration yet. And so then they appealed all the way to the Supreme Court. And I guess this is ripe for the Supreme Court because there are differences in different parts of the country, like different circuits, for whether or not you need the actual registration number from the Copyright Office.
Yeah, so we're talking about, Justice Ginsburg is going to get into which law we're talking about right away here. 17 U.S.C. 411A states that no civil action for infringement of the copyright in any United States work shall be instituted until registration of the copyright claim has been made in accordance with this title. The question in this case presents, has registration been made in accordance with Title 17? As soon as the claimant delivers the application, copies of the work and fee and all that, so a complete, accurate application, in other words, an application that would be granted, if that has been delivered, or has registration been made only after the Copyright Office reviews and registers the copyright, grants the copyright registration and sends the certificate to the copyright registrant. I have a couple copyrights myself. We've registered a few things over the years. I didn't prepare one. There's one sitting back there someplace. And it's just a piece of paper with a stamp on it, seal on it, and you have an official file with the Copyright Office as well. So one of the problems is that there are 13 appellate circuits in the United States, 13 districts, appellate districts that cover all of the 50 United States plus its territories, and then there's District of Columbia as well. And those districts do not agree whether copyright registration has been made upon application or upon the granting of the application. The United States Supreme Court, starting here, we hold in accordance with United States Court of Appeals for the 11th Circuit that registration occurs and a copyright claimant may commence an infringement suit when the Copyright Office registers a copyright. Upon complete registration of the copyright, however, a copyright owner can recover for infringement that occurred both before and after registration. Petitioner, Fourth Estate Public Benefit Corporation, we're just going to call them Fourth Estate, is a news organization producing online journalism. Fourth Estate licensed journalism works to wallstreet.com. So they wrote articles and Wall Street posted them. A news website. The license agreement required Wall Street to remove from its website all content produced by Fourth Estate before they canceled the agreement. Wall Street canceled the agreement, but continued to display the articles produced by Fourth Estate. Fourth Estate sued Wall Street and its owner for copyright infringement. The complaint alleged that Fourth Estate had filed applications to register the articles licensed to Wall Street with the Register of Copyrights. Because the Register had not yet acted on Fourth Estate's applications, the district court, on motion, dismissed the complaint, and the 11th Circuit affirmed. Thereafter, the Register of Copyrights refused registration of the articles Wall Street had allegedly infringed. The merits of the Copyright Office's decision refusing registration are not at issue in this court. So that's important. That's very, very important. So what's this is going to come into this a bit for future use of this as precedent. The Copyright Office did not then allow the registrations to go through. Normally, filing for a copyright registration is a matter of paying a fee, completing a form, and submitting or depositing a copy of the work. There's various ways to do that. They have instructions on how to do that for various different kinds of works. Here, for some reason, maybe Tactical can find out, or maybe Tactical or Kelly can find out, the Register of Copyrights did refuse registration of the articles that Wall Street had infringed, and for some reason that's not part of this opinion. That's not part of the record or part of what's before the court. The court, the U.S. Supreme Court, granted Fourth Estate's petition for certiorari to resolve a division among the U.S. Courts of Appeals on when registration occurs in accordance with 411A, as we said, and they go through the various splits there. Under the Copyright Act of 1976, as amended, copyright protection attaches to original works of authorship, prominent among them literary, musical, and dramatic works, fixed in any tangible medium of expression. An author gains exclusive rights in her work immediately upon the work's creation, including rights of reproduction, distribution, and display. This is important. Copyright exists outside of the registration. We are talking about the registration as a requirement before you can sue, and before you can sue for certain remedies like statutory damages. The Copyright Act entitles a copyright owner to institute a civil action for infringement of those exclusive rights, 501b. Before pursuing an infringement claim in court, however, the claimant must generally comply with the requirement of registration. Therefore, although an owner's right exists apart from registration, see, I'm just channeling Ruth Bader Ginsburg. That has got to shut up and just let her talk. Therefore, although an owner's rights exist apart from registration, C408A, registration is akin to an administrative exhaustion requirement that the owner must satisfy before suing to enforce ownership rights. In limited circumstances, copyright owners may file an infringement suit before undertaking registration if a copyright owner is preparing to distribute a work of a type vulnerable to pre-distribution infringement, notably a movie or musical composition. The owner may apply for pre-registration, C408F2, and there's a Code of Federal Regulations site there. The Copyright Office will conduct a limited review of the application and notify the claimant upon completion of the pre-registration. Once pre-registration has been made, the copyright claimant may institute a suit for infringement. Pre-registration, however, serves only as a preliminary step prior to a full registration. An infringement suit brought in reliance on pre-registration risks dismissal unless the copyright owner applies for registration promptly after the pre-registered work's publication or infringement. A copyright owner may also sue for infringement of a live broadcast before registration has been made, but faces dismissal of her suit if she fails to make registration for the work within 3 months of its first transmission. Even in these exceptional scenarios, then, the copyright owner must eventually pursue registration in order to maintain a suit for infringement. All parties agree that outside of statutory exceptions not applicable here, 411A bars a copyright owner from suing for infringement until registration has been made. Fourth Estate and Wall Street dispute, however, whether, quote, registration has been made under 411A when a copyright owner submits the application materials and fee required, or when the Copyright Office grants the final registration. Fourth Estate advances the former view, the application approach we're going to call it, while Wall Street urges the latter reading, the registration approach. The registration approach, we conclude, reflects the only satisfactory reading of 411A's text. We reject Fourth Estate's application approach. So once again, the ruling is already, she's announcing the ruling is in favor of the registration approach, and now we're just going to find out why. Under 411A, registration has been made and a copyright owner may sue for infringement when the Copyright Office registers a copyright. 411A's first sentence provides that no civil infringement action shall be instituted until pre-registration or registration of the copyright claim has been made. The section's next sentence sets out an exception to this rule. When the required deposit, application, and fee have been delivered to the Copyright Office in proper form and registration has been refused, the claimant may institute a civil action if notice thereof is served on the register. Read together, 411A's opening sentences focus not on the claimant's acts of applying for registration, but on action by the Copyright Office, namely its registration or refusal to register a copyright claim. If application alone sufficed to make registration, 411A's second sentence, allowing suit upon refusal, would be superfluous. What utility would that allowance have if a copyright claimant could sue for infringement immediately after applying for registration without awaiting the registrar's decision on her application? Proponents of the application approach urge that 411A's second sentence serves merely to require a copyright claimant to serve notice of an infringement suit on the register. This reading, however, requires the implausible assumption that Congress gave registration different meanings in consecutive related sentences within a single statutory provision. In 411A's first sentence, registration would mean the claimant's act of filing an application, while in the second sentence, registration would entail the registrar's review of an application. We resist this improbable construction. The third and final sentence of 411A further persuades us that the provision requires action by the registrar before the copyright claimant may sue for infringement. The sentence allows the registrar to become a party to the action with respect to the issue of registrability of the copyright claim. This allowance would be negated, and the court conducting an infringement suit would lack the benefit of the registrar's assessment if an infringement suit could be filed and resolved before the registrar acted on an application. Other provisions of the Copyright Act support our reading of registration as used in 411A to mean action by the register. Section 410 states that after examination, if the register determines that material deposited constitutes copyrightable subject matter and other legal and formal requirements are met, the register shall register the claim and issue to the claimant a certificate of registration, 410A. But if the register determines that the deposited material does not constitute copyrightable subject matter, or that the claim is invalid for any other reason, the register shall refuse registration. Section 410 thus confirms that application is discrete from and precedes registration. Section 410D furthermore provides that if the Copyright Office registers a claim, or if a court later determines that a refused claim was registrable, the effective date of the work's copyright registration is the day on which the copyright owner made a proper submission to the Copyright Office. There would be no need, thus, to specify the effective date of a copyright registration if submission of the required materials qualified as registration. Section 408F's pre-registration option 2 would have little utility if a completed application constituted registration. Pre-registration, as noted above at 3 to 4, allows the author of a work vulnerable to pre-distribution infringement to enforce her exclusive rights in court before obtaining registration or refusal thereof. A copyright owner who fears pre-publication infringement would have no reason to apply for pre-registration, however, if she could instead simply complete an application for registration and immediately commence an infringement suit. So let's see what they say in Section B here. Challenging the 11th Circuit's judgment, Fourth Estate primarily contends that the Copyright Act uses the phrase "make registration" and its passive voice counterpart, "registration has been made," to describe submissions by the copyright owner rather than Copyright Office responses to those submissions. Section 411A's requirement that registration has been made in accordance with this title, Fourth Estate insists, most likely refers to the copyright owner's compliance with the statutory specifications for registration application. In support, Fourth Estate points to Copyright Act provisions that appear to use the phrase "make registration" or one of its variants to describe what a copyright claimant does. Furthermore, Fourth Estate urges that its reading reflects the reality that, eventually, the vast majority of applications are granted. Fourth Estate acknowledges, however, that the Copyright Act sometimes uses registration to refer to activity by the office, not activity undertaken by a copyright claimant. It thus agrees that to determine how the statute uses the word registration in a particular prescription, one must look to the specific context in which the term is used. As explained above, the specific context of 411A permits only one sensible reading. The phrase registration has been made refers to the Copyright Office's act granting registration, not to the copyright claimant's request for registration. Fourth Estate's contrary reading stems in part from its misapprehension of the significance of certain 1976 revisions to the Copyright Act. Before that year, 411A's precursor provided that no action or proceeding shall be maintained for infringement of copyright in any work until the provisions of this title, with respect to the deposit of copies and registration of such work, shall have been complied with. Fourth Estate urges that this provision posed the very question we resolve today, namely, whether a claimant's application alone affects registration. The Second Circuit addressed that question, Fourth Estate observes, in Vacheron and Constantin Lee, watches. Let's try this again. Vacheron and Constantin Le Culture watches. I really have no idea how to pronounce that in French. Versus the Benrus Watch Company in 1958. In that case, in an opinion by Judge Learned Hand, great name, love the name, the court held that a copyright owner who completed an application could not sue for infringement immediately upon the Copyright Office's refusal to register. Instead, the owner first had to obtain a registration certificate by bringing a mandamus action against the register. The Second Circuit dissenter would have treated the owner's application as sufficient to permit commencement of an action for infringement. Fourth Estate sees the 1976 revision of the registration requirement as endorsement of the dissenter's position. We disagree. The changes made in 1976 instead indicate Congress' agreement with Judge Hand that it is the registrar's action that triggers a copyright owner's entitlement to sue. In enacting 411A, Congress both reaffirmed the general rule that registration must precede an infringement suit and added an exception in that provision's second sentence to cover instances in which registration is refused. That exception would have no work to do if, as Fourth Estate urges, Congress intended the 1976 revisions to clarify that a copyright claimant may sue immediately upon applying for registration. A copyright claimant would need no statutory authorization to sue after refusal of her application if she could institute suit as soon as she has filed the application. Noteworthy, too, in years following the 76 revisions, Congress resisted efforts to eliminate 411A and the registration requirement embedded in it. In 1988, Congress removed foreign works from 411A's dominion in order to comply with the Berne Convention for the Protection of Literary and Artistic Works, bar on copyright formalities for such works. Despite proposals to repeat 411A's registration requirements entirely, Congress maintained the requirement for domestic works. Subsequently, in 93, Congress considered but declined to adopt a proposal to allow suit immediately upon submission of a registration application, 1993, in a House Bill 103-338. And in 2005, Congress made a pre-registration option available for works vulnerable to pre-distribution infringement. The Artist Rights and Theft Prevention Act of 2005, Congress chose that course in face of calls to eliminate registration in cases of pre-distribution infringement. Time and again, then, Congress has maintained registration as prerequisite to suit and rejected proposals that would have eliminated registration or tied it to the copyright claimant's application instead of the registrar's action. Fourth Estate additionally argues that, as registration is not a condition of copyright protection, 408A and 411A should not be read to bar a copyright claimant from enforcing that protection in court once she has submitted a proper application for registration. but as explained above, the Copyright Act safeguards copyright owners, irrespective of registration, by vesting them with exclusive rights upon creation of their works and prohibiting infringement from that point forward. If infringement occurs before a copyright owner applies for registration, that owner may eventually recover damages for the past infringement as well as the infringer's profits, see Section 504. She must simply apply for registration, receive the Copyright Office's decision on her application before instituting suit. Once the register grants or refuses registration, the copyright owner may also seek an injunction barring the infringer from continued violation of her exclusive rights and an order requiring the infringer to destroy infringing materials. See Section 502 and Section 503. That's important. So that means that if you are incurring economic damage and incurring, if there's damage that you feel would be irreparable, you still seem to have a requirement to get that registration finished and completed and back in the mail before you can institute suit and get that injunction. You should be able to go back in time and get money damages for those damages, but I'm not confident about this paragraph here. Let's go over it again. If infringement occurs before a copyright owner applies for registration, that owner may eventually recover money damages for past infringements, including profits. She must simply apply for registration, receive the decision. Once the register grants or refuses, because remember, a refusal allows a suit as well, the copyright owner may also seek an injunction barring the infringer from continued violation. So if you don't have your work set for pre-registration properly and you get it out there and published and then you discover that you have an infringement problem, you may have no remedy during the in-between time between registering your work and being able to file suit once that registration is either granted or refused. Fourth Estate maintains, however, that if infringement occurs while the Copyright Office is reviewing a registration application, the registration approach will deprive the owner of her rights during the waiting period. The Copyright Act's explicit carve-outs from 411A's general registration rule, however, show that Congress adverted to this concern. In the pre-registration option 408F, Congress provided that owners of works especially susceptible to pre-publication infringement should be allowed to institute suit before the register has granted or refused registration. Congress made the same determination as to live broadcasts. As to all other works, however, 411A's general rule requires the owners to await action by the register before filing suit for infringement. Fourth Estate raises the specter that a copyright owner may lose the ability to enforce her rights if the Copyright Act's 3-year statute of limitations runs out before the Copyright Office acts on her application for registration. Fourth Estate's fear is overstated, as the average processing time for registration applications is currently 7 months, leaving ample time to sue after the registrar's decision, even for infringement that began before submission of an application. That's still 7 months of lost time, though, in my humble opinion. True, the statutory scheme has not worked as Congress likely envisioned. Registration processing times have increased from 1 to 2 weeks in 1956 to many months today. Delays in Copyright Office processing of applications, it appears, are attributable in large measure to staffing and budgetary shortages that Congress can alleviate, but courts cannot cure. Unfortunate as the current administrative lag may be, that factor does not allow us to revise the congressionally composed text of Section 411A. For the reasons stated, we conclude that registration has been made within the meaning of 411A not when an application for registration is filed, but when the register has registered a copyright after examining a properly filed application. The judgment of the Court of Appeals for the 11th Circuit is accordingly affirmed. And so that is the new rule. That's the new law. That's basically now good law. If you don't yet have a registration, you should not be able to file a copyright suit. This is important for all sorts of different copyright cases, not the least of which are the ones that I work on. We lots of times settle or fight cases where the registration numbers are currently application numbers, not granted copyright registrations. So those are technically not live claims at that time. It's not something that every case is going to have to deal with. I don't really want to go into my theory of my case here on this stream, but that's going to affect a lot of the way copyright is dealt with. It really seems like only live broadcasts and certain types of pre-distribution infringement. Here's a legal question for you. Did that opinion make clear whether you only had to be a type of work that could have pre-distribution infringement, or did the infringement that you're suing over have to include pre-distribution infringement in order to take advantage of those requirements? I think it seemed like you only had to be in that category. You had to complete the pre-registration requirement process. There's a procedure in there, and the Register of Copyrights gets to set some of that procedure. It seemed like if you did that, that's what you need for pre-distribution infringement and pre-registration requirement and all that. If you are not one of those categories, a live distribution or pre-distribution, likelihood of pre-distribution infringement, if you don't fall into those categories, then you just have to wait. If you, let's say you make a video game and you don't pre-register it, and you find EA is selling your game in violation of copyright. Well, it seems like now you go to the Copyright Office website, you submit a copyright registration, and you wait 6 or 7 months for your registration to be granted. Then you can sue EA and recover all their profits and all that. However, what if it's not EA? What if it's a website host claiming a safe harbor for some customer in Russia? You need to get an injunction, right? You need to get like some kind of DMCA takedown notice or something like that. Yeah, a DMCA takedown notice should work, but what if they ignore it? You don't have a copyright registration yet. You can't go to court. You can't sue. So there are going to be people caught in a middle there. You can eventually sue, and maybe there's an argument that because they didn't comply with the DMCA takedown notice that they're not in the safe harbor. There's one possible remedy. These are the unknown things, though, that we're going to have to work out next. There is an expedited process when you go to register a copyright. Yes, you can select that this is a copyright that's subject to suit and ask them for expedited processing. I don't know that the expedited processing is guaranteed.
I also just wanted to clarify what happened with the denial of the copyright registration. That apparently it wasn't an individual article that was being registered for copyright, but rather it was a database. So it was the collection of articles.
Yeah, they didn't properly.
So then the Copyright Office says that that curating all of these articles was not sufficiently creative enough. So even though each individual component could have copyright protection, the database of articles didn't.
Okay, so that makes sense too. Rye Scorpion notes that the expedited process costs like $800. So there's a reason why you might not do that for smaller amounts of infringement, or if you just simply don't have a budget for it. So that's one reason why you might not go for expedited processing. Some people have asked how I don't speak French. I actually took 3 years of French in middle school, what we call middle schoolers, 6th, 7th, 8th grade here. I remember almost none of it. I am not actually French. People in France would not be named French. Like what happened with French was I'm actually Polish, and the name was Fraszkowski, and so many people couldn't pronounce it or spell it or write it or whatever that my grandfather changed it. I think they said 1958 changed it to French because. Well, there's two theories. Some people just think he changed it. He selected a name and changed it. There isn't like a French family history written down here. But I think that he had a heavy Polish accent, and some of the, other workers or because we're a mixed culture over here in America, may have mistaken his Polish accent for French or something and called him Frenchie, or maybe he wore a funny hat and they called him Frenchie or something. And so he changed his name to French. That was my theory. Okay, so what do we think of the notorious RBG's opinion? I have to be careful there because I keep wanting to say RGB. for red, green, blue LEDs.
This was another unanimous opinion, wasn't it?
Yeah, this was unanimous. 100% of the time, every time. So that doesn't leave a whole lot of room for questioning the opinion. And this brings up the quote, "We are not final because we're infallible," or "We're not infallible because we're final. We're final." It's one of the, it's one of them. We're not final because we're infallible. We're infallible because we're final.
I love that you're trying to say infallible so much and you keep messing up the quote. I'm so entertained.
It's a hard quote to get. It works both ways, technically. But it means that they're the final word. There is no further court of review, so it's effectively an infallible opinion. We now have to just take this opinion and make it work until some case or controversy presents itself ripe for review. And remember, that's a lot in there. A case or controversy has a whole legal definition to it, and ripe for review means it has to have followed the proper procedure to get to the court of review. So it's going to be a long time before we review this question again, even if we started today. Thank you to our Patreon supporters at the $50 level in the month of March. Thank you for Jonathan Doe, John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Chris, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Aspernari. And thank you to the 170 plus $5 plus supporters scrolling on the LED panel behind me. And I'm sure that Brandon will put you in the crawl. I'll give him some dog video to insert here as we take the thing out. I love you all. Thank you for joining me, and I'll see you in the next videos. Bye. Yeah, if you don't bring your ball now, you're not going to find it again tomorrow. All right, inside, everybody. Inside. Inside. Don't look at her. Look at me. I'm your master. No, and you're not getting either of these. Oh. She got one.
You got two?
I got the other one. Oh, she got to it first.
She got a good ball.
Yeah,
Bring your ball in.
yeah.